This is a continuation of where we left off last, and we're going to be discussing in this brief segment the last category of exceptions to the at-will employment doctrine in this jurisdiction. And that category would be the tort-based public policy whistleblower type of retaliatory discharge case exceptions. And with that, I want to draw your attention to an appellate court case in this jurisdiction entitled Mackey versus Vaughn Chapter PVA. That case should have been available for your review and study, so hopefully you've made good use of it and already read it. Let's talk about that case. And by the way, this Mackey case is a seminal case here in this jurisdiction. It's also been reported throughout the country, and it is a reference to the Illinois jury instructions for civil matters involving retaliatory discharge cases here in Illinois as well. So it's an important case, and the issue in that case was whether the former employee of the Vaughn chapter of the Paralyzed Veterans of America stated a cause of action for retaliatory discharge by alleging he was terminated after reporting what he believed was the theft of chapter property when a member of the chapter's board of directors downloaded the organization's mailing list for use by a private business. There was a belief by the plaintiff that a crime had been committed. He reported that belief to the organization and also to an outside law enforcement agency. The allegations are that he was fired shortly thereafter. This case was dismissed at the trial court level, and there was an appeal to the appellate court and a reversal and remand of the case. Take a look at the case itself, and by the way, I wanted you to see an example of what a reported case looks like. In our text book, you'll find synopsis of cases or shortened, condensed versions which the author wants you to examine in limited format. This case, for example, that we'll study, the Mackey case, is an actual reported case from a reporter. I believe it's LexisNexis is the edition that you're looking at. Look at the section where it indicates stating a claim for retaliatory discharge. General principles. The court points out that the tort of retaliatory discharge is an exception to the general rule that an at-will employee can be terminated at any time with or without cause. You're going to see a case cite following that rule. That case cite is Palmatier versus International Harvester Company. That case stands for the precedent which that rule is based upon. So for every rule that we'll see in our case studies, there is a citation resource following it. Let's go on to the very next sentence where it indicates this tort balances the respective competing interest of employers and employees in efficient business operations and in earning a living. And the case cite then is Beline, 940 F2 at 186. Again, that's a case citation that represents a precedent for that rule of law. So the tort of retaliatory discharge is a limited exception within this framework, as the appellate court points out. Now, going back to the introductory section where the appellate court reveals that the tort of retaliatory discharge exists. It's not a contract-based claim, it's a tort-based claim. Now, earlier we discussed contract-based damages, and in that section we discussed that if there's a breach of contract, the measure of loss is based on economic terms. In other words, economic losses would be the remedy. For tort-based claims, economic losses certainly are a remedy as well, but compensatory and punitive damages may be available. If you look at the word compensatory, the root would be compensate. What type of compensation might be available to a prevailing plaintiff in these types of cases? Perhaps pain and suffering, emotional distress damages, damages for embarrassment, humiliation, and related loss. Those damages may be available in addition to economic losses. Compensatory damages by their nature would be non-economic in this context. Let's look next at punitive damages. Punitive damages, if you'll examine the root word, would be punish. Punitive damages are designed to punish and deter, by example, the type of conduct or behavior which is found in that particular case or setting. The aspect of punitive damages would be to serve as an example so that other organizations would not follow and engage in that same type of behavior. To punish would not be to compensate, but to allow for damages to send a message, so to speak, to the community at large, as well as to the respective company or defendant that has been found liable for punitive damages. Let's move on to further examination of the information found in the Mackey case. The appellate court goes on to say that to state a claim for retaliatory discharge, an employee must allege: 1, he or she was discharged; 2, in retaliation for the employee's activities; and 3, the discharge was in contravention of a clearly mandated public policy. Well, let's look at the term public policy. The court in Mackey points out that the matter must strike at the heart of citizens' rights, social rights, duties, and responsibilities before the court or the tort will be allowed. There's no precise definition of public policy according to the appellate court. So public policy may be based on a variety of factors, but according to this court, the matter must strike at the heart of citizens' social rights, duties, and responsibilities. Now, there are a number of cases which are reported within this decision that reflect public policy-based levels of protection that a plaintiff may invoke. Make sure that you read through this case in detail. The court, for example, lists leading Illinois cases and also federal cases, all of which focus on the aspect of a public policy violation. In short, public policy probably would be found to exist if the matters involve some form of public interest in the form of health, welfare, or safety, which affect the general citizenry as opposed to a very private, narrow interest. So when you see situations that impact the larger societal interest, air quality, for example, avoiding reporting crimes, for example, such as in the Mackey case, there was a citizen crime fighter theory that was used. Something that affects the general citizenry regarding matters of interest, safety, health, well-being of the public. That may form a so-called public policy that a plaintiff may invoke and seek protection by. There's a lot of information in the Mackey case. This is a case, however, involving a common law retaliatory discharge claim. You'll probably also note, if you haven't already in your readings, that there are other cases involving violations of whistleblower acts. Now, whistleblower acts are statutory in nature. Common law public policy is based on case law interpretation for those types of cases. And you'll see that there must be a termination in order for there to be liability invoked. With whistleblower type statutes, which are products of the legislature as opposed to courts, retaliation may not require a termination. For example, allegations of a so-called retaliatory demotion or retaliatory failure to promote after an employee has invoked some type of protected activity or communication may be allowed under a whistleblower statute, but would not be allowed in a common law retaliatory discharge claim based on public policy matters. So the rule would be, unless there is a discharge, there would be no liability under a common law public policy based exception to the at-will employment rule. Hopefully this past week you've learned categories of examples that represent exceptions to the at-will employment rule. From this point forward, we will be studying detailed examples found in case law as well as statutory authority, all of which form exceptions to this general rule that one can start work or end work at their discretion, or the employer may fire the employee at its discretionary will, with cause, without cause, for good reason, or not. Thank you very much.